Good morning, Justice Maya.
You obtained two degrees, law degrees from Vista University in 1997 and 2001.
Correct, Justice Maya.
A BU recent and a LLB.
Correct, Justice Maya.
And then you would have obtained the LLB while you were already on the job market.
The LLB, yes, correct, Justice Maya.
All
yes.
right. Your background is in prosecution.
Yes, my background.
Largely.
Correct, Justice Maya. I've been with the National Prosecuting Authority until I resigned and joined the bar of the Johannesburg.
That is
Bar
from
Council.
1999 until 2012 when you had
Correct, Justice Maya.
clambered all the way up the ranks to become a senior state advocate.
Correct, Justice Maya.
You were with the Assets Forfeiture Unit.
I started off as a prosecutor in the district court, and then regional court, and then thereafter appointed as, after being admitted as an advocate in the High Court, I was appointed in the Asset Forfeiture Unit as a state advocate, and then thereafter the senior state advocate. And on several occasions, I was also appointed to act as a deputy director.
Right. And then you decided to join the bar.
I joined the bar, yes, in 2012, after I've resigned from NPA.
Joburg Bar, Polokwane Society of Advocates,
Yes, I
and
did.
the Northwest.
Correct, Justice Maya. I did pupillate with the Johannesburg Bar Council. And then thereafter, I think 2014 or 15, I joined the Polokwane Society of Advocates after it was formed. And then thereafter, the Northwest Bar in 2021, I think, yes.
Okay. What kind of work did you do in your practice?
In my practice,
Sorry.
in my practice, Justice Maya.
Yes.
Yes, Justice Maya, in prosecution, it was mostly criminal. So after I joined the bar, I got much interest in civil litigation and motion. That most of my work was in civil litigation, even though I still did some criminal matters, but 90% of my work was civil.
All right.
Yes.
What kind of cases exactly?
The civil.
Yes.
It was medical negligence, unlawful arrests, and some applications that I would do.
All right. When did you start acting at the
It was,
Northwest Division? Your first stint was in July 2020.
correct, Justice Maya, it was July 2020.
And how many acting stints have you had with them since?
Last week, Justice Maya, I managed to get hold of my court books and I calculated. All in all, it's 73 weeks. Yes. Okay. Because I'm still acting now until the end of October.
Oh, I see.
Yes.
And you have you've sat in both civil and criminal matters?
Yes, Justice Maya, in the Northwest Division, we do everything. I did opposed, unopposed, civil trials, criminal trials, appeals. We do everything, Justice Maya.
Right. And have you been able to produce written judgments?
I was able, correct, Justice Maya, I was able to produce written judgments. I was also counting them, and I stopped at 90. When I started to act, my DJP by then encouraged me that as part of training, I must try to pen as much judgment as I can. The more I pen them, the more experience I will get, and the more easier they will be for me.
Indeed.
Yes.
Any of them reported?
Not in the Juta or LexisNexis, only on SAFLI, Justice Maya.
All right. Do you have any old reserve judgments that you...
No, Justice Maya, I don't have any reserve judgment.
In your application form, you mentioned 3 part-head matters. What is their status now?
Justice Maya, if you may see on those in the part-head matters that I've written down, there are more than one accused. One is 11 accused, one is 5 accused, and they are still pending in those part-head matters. I put them, they were set down during recess of June, but they could not be finalized. The reason being, June we had a challenge of load shedding, And sometimes, on some days, the accused is sick, some days is the legal representative. So there are many challenges when one is dealing with partly heard matters, especially of more than one accused and more than one legal representative.
Something caught my eye. In I think 2 of the comments that have been submitted by the professional bodies, there's mention that you have resigned your membership of the bar in pursuit of your acting stint. Can you explain that?
Correct, Justice Maya. If I may go back a bit, the reason why I joined the bar, I've always wanted to be a presiding officer, either a judge or a magistrate. So when I arrived at the bar, I contacted the office of JP in Gauteng, and I was told that I can only be able to act after 12 years experience. And then I noticed that, oh, okay.
12 years experience
At the bar. That's what I was told. I'm not sure whether it was correct or not. For me, the practical experience at the bar. So now, and then one of my senior colleagues at the bar were aware that I'm there for me to be a judge or to be a magistrate. And then the opportunity came from Mafikeng, and then I grabbed it. And after grabbing it, I acted the first stint in July, the second one, the first term of 2020. And then thereafter, I started to pack my practice bit by bit so that I can be able to focus on acting. And then I resigned from the bar because being the member of the bar also, it goes with costs that were going to be heavy for me whilst I'm acting and also being the member of those bars. So that's the reason why I resigned, to pursue my acting stint.
Oh, I see. So if you are not recommended for appointment, you will go back and start again?
I will go back and start again, Justice Maya. Yes.
Okay. The General Council of the Bar says some of its members have expressed some misgivings about your experience with civil work. They say you have limited knowledge of civil law to quote them verbatim. What would you say to that charge?
Justice Maya, I don't think that comment is correct. I gave myself 10 years to be at the bar and also 12 years to be with NPA. And also at NPA, we had some portion of, AFU has some portion of civil law. So in my practice, as I've said, 90% of my trials that I was running were civil, were of the civil matters. I was in court frequently I was in court. I'm a court person, so even in practice, I'm in court frequently. I'm not afraid of running trials. I'm there in court, and if I may add, Justice Maya, is that most of the pupils that will come to me, I always told them that, when you appear in court, you are going to deliver a matter. The judges won't bite you. The judges won't give you a hiding. Just go there and present and be yourself. So that is what I was doing also with myself personally. I therefore don't believe that I don't have enough experience. I have enough experience. And also most of the judgments that I penned in my PK are the civil judgments.
Well, they make more troubling observations that some members have complained about your short temper, that you are confrontational in your engagement with counsel, and that you are not punctual in starting court proceedings. Would you like to comment?
Thank you, Justice Maya. I took note of that comment, and Justice Maya, I accept that as judges we should be criticized, but the criticism should be constructive and fair and in good faith. Unfortunately, that comment, Justice Maya, doesn't state at what stage did I show my temper. If I want to blow my own horn, Justice Maya, I'm a very kind-hearted person. I'm a polite person. I make sure that everybody that appears in my court becomes comfortable. I've never shown any signs of short temper. And if indeed, Justice Maya, I had temper and all those things that they mentioned, they could have complained to the JP maybe in writing or physically. I've never received any complaint from anyone, or I've never, even in my court, have any interaction with any of the litigants. If I may add, Justice Maya, it's, according to the experience that I have, the period that I've spent in acting, I've noticed that as judges, we do make unpopular decisions, and the losing party will always complain. So I should think that maybe the person who thinks that I'm short-tempered is the losing party, but I know myself personally. I'm a very kind person. I don't have any short temper. And regarding punctuality in court, Justice Maya, I'm always present. I'm always on time in court. I'm sure my JP could have called me to order if indeed I'm not punctual in my court. Unfortunately, as I've said earlier, the person that complained about that did not clarify under what circumstances did I not become punctual. We have our own challenges of load shedding. Sometimes, maybe there was a challenge on that day, but I'm a very punctual person, Justice Maya. And regarding confrontational, Justice Maya, when I go to court, I prepare my file. When I started to prosecute many years ago, we were trained thoroughly that you do not go to court without knowing your docket. And then in practice, when I did pupillage, we were trained that know your file or your brief as much as you know yourself. The same is happening. It's the same style that I apply also as a judge. I prepare myself thoroughly. I do my own research. I go through the heads of arguments of both parties if it's an application. And when I arrive in court, I do not intend to be, I can never be confrontational. In fact, in my court, I leave the litigants to present their case as much as they want. Maybe by being confrontational, they mean when I try to clarify the issues that they've raised before me. But that's, I can never be confrontational, Justice Maya. As I said, I'm a very kind person. I know myself.
Yes. Well, the allegations are indeed bare ones. There's just no details. One that does not know what you did to whom when. You are a chairperson of the tax board?
I was Justice Maya, yes.
Mm-hmm. For how long?
It was for 5 years. I think it was 2016 until 2020. As a chairperson of the tax board, Justice Maya, you are supposed to be briefed by the commissioner. And unfortunately, as for these 5 years, I only received 3 briefs, and all of them were settled at the door.
So you did not get to do much?
Yes, I did not get to do much, yes, Justice Maya.
All right. You have mentioned that you mentor pupils and offer all kinds of support to young people. Do you want to tell us a bit about that?
Yes, Justice Maya, when I did pupillage, my challenging courses was motion and legal drafting. And I've noticed that most of the pupils, we need a practical training, especially of legal drafting. So I took it upon myself, since I've passed pupillage, since I've started practicing from 2014, I've been having groups of pupils that I'll be training, those especially that I will approach one, and that one person will come with his own people. But what I used to do in Polokwane, I will request the class, and then I'll go there during the weekend. Friday, Saturday, Sunday, I'll be with them, wherein I give them a topic, and then they draft, and then I personally show them how to draft a particular document, because I think that is what I needed during pupillage. As a prosecutor, it was the first time that during pupillage that I saw the particulars of claim and some documents. So I've noticed that some of our pupils are failing pupillage because they do not get enough training. And regarding young girls, I try my best, Justice Maya, especially in the rural areas, wherein the girls need to know and have confidence in themselves, need to know that it's not by miracle to be where you want to be. Irrespective, we know that we have the teenage pregnancy problem in South Africa. So those that have kids in the young age, I encourage their parents that support your children, let them go to school and pursue whatever they want to do. Unfortunately, I've been trying to encourage them to do law. They are not interested in the law. They took other fields.
I don't blame them. And you have assisted some financially, actually, by paying their way through school?
Yes.
Through university?
Yes, correct, JP. I make myself available. By assisting them, I don't mean that I pay school fees. You know, in the rural areas, the kids, some of them were not even aware that there's NFSAS. They will struggle to have money to go to the university after being accepted to go and register. So those things, those fields, we will appoint a girl, and then that girl that you see potential in that particular person, you mentor that girl. And then thereafter, let him register and mentor him through the school. But Justice Maya, I would like to mention that I'm of a view that I'm not only supposed to mentor girls. I'm of a view that we are leaving the boys out.
Yes.
So if there is a boy, also because I have a boy child, I saw that if you always say girls, 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 what about the boys that we are raising? Are they not going to be the same problem that their fathers are now? Because we are not giving them those opportunities. So if there's a boy also that I see potential in that boy, I try to hold the hand of that boy and educate. Not by, I don't have money, I don't have money, Justice Maya, to pay school fees, but at least assist them. That there's NFSAS, tell the parents, because you need to, in the rurals, you need to talk to the parents before you talk to the child. Tell the parent that there's this and this and this, your child can indeed be successful, and indeed they do graduate and get some work wherever. Even at church, I do that at church. Whoever that needs my assistance, they come to me and I make myself available. And regarding pupils, most of the pupils in Polokwane are in the rurals, and especially in 2020 during COVID, they have to run classes through virtual. Most of them will call me and tell me that we don't even have money for data. Some pupils don't even have money to go and attend classes. I don't have money, but I will try and source money from some of our colleagues and be able to fund those pupils. After I've done my own research, because I hate to be taken for granted, and I know that for sure these people need assistance. Some will be taken by the different bus, but they don't have money to register for them to can be able to proceed with pupillage. I will fund them, and then after they register. And some that are staying in Polokwane or around Johannesburg, they don't have money, they rent rooms to can be able to stay and do their pupillage. I do fund some such people, Justice Maya, but I want to insist that I don't have money, I don't fund them from my pocket, I do some means for them to be able to get those fundings.
Yeah. No, thank you, Ms. Mahlangu. JP Hendricks?
Thank you, DCJ. Good morning.
Good morning,
Judge
JP.
Mahlangu. How are you?
I'm fine, and you, JP?
Fine, thank you. You have been acting in our division for a considerable period of time.
Correct, JP.
You have been called by my predecessor.
Correct, JP.
Yeah, and your acting stint is now extended until the end of this month.
Correct, JP.
Yeah. You also stated that you penned something like 90 judgments.
Correct, JP.
Yeah. So, how do you experience it, acting in the Northwest Division?
JP, acting on itself is a very daunting experience. You know, I was a prosecutor, and then from me being an advocate, I had to shift my mind, and especially when representing the accused person, to stand on the other side of the bench. Now, being acting as a judge, it was something very, very different from what I was experienced to do. But due to the help and the cordiality of the other judges in the Northwest Division, it became easier. I remember when I first got there and to act, and I signed the certificate of oath, the DJP by then told me that, you know what, you are a judge. You must be responsible and accountable for what we are going to do in your court. Acting is something else, but be responsible. So acting in the Northwest, it became easier for me because of the support that I got from other judges. It's easier to just go knock at the door and ask for assistance. And the other thing that I've said earlier is preparing, made my acting in the Northwest easier. And the other thing, JP, that made my acting in the Northwest easier, I think because I can speak Setswana easily, it became easy for me to blend in with the people of the Northwest. Thank you, JP.
You are referring to the DJP by then. Are you referring to me?
I'm referring to you, just JP.
Yes.
Yes, you gave me the very good support, and I thank you for that.
Yeah. One concern that I also picked up, but you were asked by the DHCJ already about it, is the GCB's comment about your temper, you are not being punctual at starting court and confrontational in your engagement with counsel. Now, for the record, no complaints was brought to my attention.
Thank you, JP.
Yeah, and also you were nominated by Advocate T. Masike,
Correct, JP?
and from the nomination letter, the following appears, and I quote, I submit that Acting Judge Mahlangu is appropriately qualified, has the necessary experience and temperament to be appointed as a judge, unquote. Do you have any comment on that?
Correct, JP. Yeah, Advocate Masike is correct. He's one of the advocates that normally appears in my court, especially in the unopposed role. I've never shown any temper, and I'm not a temper. I don't have a short temper. Like I said, I know myself.
Yeah. Do you have any long trials that you are currently doing, civil or criminal?
I have 3, JP. In fact, there are 4 now. Yes, I have 3 criminal trials that are running, that are very long. The first one with more than 11 accused, the charges there are 21, 21 charges, and there are 7 legal representatives. And the second one, I think it's 4 or 5 accused persons, and each accused person has his own legal representative. The charges there are 11. And then the civil one is 19 plaintiffs, if I'm correct, JP. And even though they are represented by 1 legal representative, but the charges, the claim against the defendant in that are plus minus 10. So they are very, very long trials. Thank you, JP.
And how do you find the workload in the Northwest?
JP, I've only acted in the Northwest, and I've always had the people from Johannesburg saying the workload. The Northwest workload is too much. There's too much work. Like, I'm in court every day. I don't know if maybe because of the shortage of judges or what, JP, but there's a lot of work. I'm in court running trials. Thursdays is opposed applications and Fridays, but there's no day that I've since acted and I was never in court in the Northwest. The workload is too much, JP. Even when I go to circuit, like I was in circuit court last week, there were 3 trials that were set down. So the workload is too much in the Northwest, where both criminal and civil.
Yeah. During the July recess, my predecessor, Judge Leo, called me and Judge Peterson and Judge Jaje to come and assist during the recess, and you were doing recess duty. Were you overwhelmed by the work, the amount of work? Was it too much for you to do? Or what was the situation?
JP, what happened is I was on recess duty during the first week of recess, and the second 2 weeks it was one of our sisters that got ill. So the JP requested me to step in as I was already in court. And then the reason why I was there, I had this part-head matter of 5 accused persons that I was supposed to be, that was set down for that 2 weeks. So now I had to step in and be on recess duty. And when we are on recess duty, you are doing the unopposed, the opposed, all the work is coming to you as a judge. So during the last week of when I was on recess duty, this trial was still proceeding, the witnesses were coming in court, and on Wednesday, I received the unopposed motion roll, which consisted of 120 matters, and then I already have 5 urgent applications, and there were 2 return days applications that were also supposed to be heard on Thursday. I thereafter called the JP because he said to me, you are going to be on recess duty to step in the shoes of our sister that is not well, but should you have any challenges, please let me know. I've already talked to other brothers of ours to come and assist. And then I talked to JP Leo, and then he called the other judges that were available to come and assist. And indeed, on Thursday, the other judges came. The reason why I went to her, I didn't want to postpone any of these matters because the litigants were there and the clients will suffer because the litigants will be paid for the day on which they were, that they booked. So what I did, and also my trials, the witnesses were in court, and I normally run my opposed until 1. My aim was to start with my trial at 2, and on top of that, we had agents. And agent applications are agents. You cannot stand them down on any other day. You need to deal with them. But JP, what I can say now is that I am indeed managing to deal with the overloaded role. It's just that on this day, I was on research duty, and I had other matters already that were on the roll.
Yes. I also see that you have some business interest.
Yes, JP, correct.
Yeah. You are, is it a director of a company or a shareholder?
A shareholder in one company.
And?
Yes, and an executive director in one company.
Yeah.
Yes.
And what will happen to this should you be recommended for appointment?
I intend to resign in one of them. It's one company that I'm a shareholder. And the second company, JP, we started it in 2019, and unfortunately, because of COVID, it did not pick up. But I intend also to resign from it.
Yeah. You have resigned from the bar. Now, did you resign in anticipation that you may be recommended for permanent appointment?
JP, I've been acting since May until end of October. So I just sat and realized that to pursue my acting appointment, let me resign, because being a member of the bar, it comes with own costs. So should I not be appointed at JP, I will go back.
How many reserve judgments do you have?
I do not have.
currently?
I'm sorry, JP, I do not have any reserve judgments.
Yes. Thank you, DCJ.
Mic is off, sorry. I was asking if you have questions for the candidate.
No, not.
All right, no, that's fine.
Thank you very much, DCJ. Good morning, Judge.
Good morning, Professor Marumo.
Marumo
Oh,
Akai.
Marumo Achaye. Yes, good morning.
I see that in your bundle of documents, there's one matter where you had occasion to deal with the Companies Act. Centurion Academy and Quaver Training. Do you remember that matter?
Yes, I remember it.
I'm not sure if it would be fair for me to deal with the facts of it. Do you still remember them, or should I just ask generally?
I think you should just ask general. I think I still know the facts.
All right. I just want to understand. In this case, you dealt with sections 344 and 345 of the old Companies Act of 1973. And correctly so, because while that legislation has been repealed, chapter 14 of it, it is still in force in relation to insolvent companies. I just want to get your view, because I really wanted to deal with the case itself, but nonetheless, I just want to get your view, because currently we are having the Companies Act of 2008 that deals with solvent companies and to some extent a business rescue. What I want to understand to you, this parallel regulation of insolvencies in South Africa, is it sound? Is it something that should continue, or should the legislature approach the question of insolvency differently and perhaps have one legislation that regulates both insolvent and solvent companies? The liquidation of solvent and insolvent companies, that is.
Professor Marumo Achaye, I just want to place it here that this matter has been appealed, and I granted leave to appeal. So I don't want to state things, the facts, and be as
Yes.
if I'm defending my
No, it's fine.
judgment.
We
But-
don't have to deal with the facts of it.
Yes.
Let's just deal with law generally.
I'm of a view that the law relating to insolvencies should continue as it is.
With parallel regulation.
Yes,
Oh, okay.
thank you.
Thank you very much, Deputy Chief Justice.
Thank you, Commissioner. Commissioner Nyambi?
Thank you, TCJ. Morning, ma'am.
Good morning, Commissioner Nyambi.
Besides the negative comment by the GCP, if you can share with us your good attributes that will make you to stand out, as you know that you have others that are for the same position that we must seriously consider as a commission.
Thank you, Commissioner Nyambi. Commissioner Nyambi, I have passion for justice. I'm a very, like I said, I'm a very kind person and willing to listen. I'm a good listener to the litigants. I'm a hard worker. That is why I don't have reserved judgments. I deliver my judgments, the latest in 6 weeks, and most of them I deliver them. I work through them in the weekend, so the earliest is 1 day or 2 days. I'm always prepared. I have the good relationship with everybody that I'm working with. I'm a very brave and confident person. When I go to court, I make sure, I know that whatever judgment that I'm going to grant one of the parties might not be happy, irrespective of whether I've worked with that particular litigant or not, and irrespective of whether that particular litigant has 30 years experience as a senior counsel or 1 year experience. I treat them equally in my court. And when I realize that the litigant is not getting or is not getting through the law that he or she has presented on paper, I nicely guide them. I therefore, Commissioner Nambi, if I may say, I'm a very strict person, if I may put it that way, that does her work with diligence.
My last question. In South Africa these days, the buzzword is the independent judiciary. So, in your own words, can you please describe your understanding of an independent judiciary?
Commissioner Nyambi, in my words, I would say the independence of the judiciary, personally, I would say not to be easily influenced by any, whether it's the media, by any other means that will try to influence my judgment on how I deal with the matters in court, and to make sure that each and every matter that comes before me, I deal with it fairly and in terms of the law that applies to it, and after listening to the litigants. Therefore, by so doing, I think I'll be independent without being told by any other person on how to deal with a particular matter.
I was not specifically referring to yourself. I was just asking about an independent judiciary.
Okay, I'm sorry about that, Commissioner Nambi. Yes, the independent judiciary, the judiciary that is not easily influenced by any other means, and ensures that each and every matter that appears in court is treated fairly and in terms of the law of the country.
Is it possible to influence judiciary?
It's not possible. As far, according to my experience as acting, it's not possible, Commissioner Nyambi, to influence the judiciary. But the judicial independence goes there, that the judicial independence must be, as a judge, I must do whatever I think, give the decision in terms of the law and in terms of the papers that are appearing before me.
Thanks, Ms. Mahlangu.
Thank you.
Thank you, TCJ.
Thank you, Commissioner. Commissioner Matolochi,
Mr. Chair, can I just make one follow-up?
follow up? All right.
Yes. When you say the judiciary is not easily influenced, what do you mean?
I was answering Commissioner Nyambi's question that, like I said, the judiciary, the independence of the judiciary is not to be influenced by any other means. Commissioner Jesse, it's because we watch the news, we are on social media, everything. The matter that is going to appear in front of me might have been on the news. So it's by being influenced is that I should think that is the meaning of being influenced, that I must apply my independent mind.
Yeah, my problem is you say the judiciary must not be easily influenced. Does that mean it can be influenced, but that must not be easy to do?
No, it can't be influenced, Commissioner Jesse.
Thank you, Commissioner.
DCJ, can I just follow up on this
Yes.
question again?
Yes.
Ms. Mahlangu, lately in South Africa, they talk about state judicial capture. Do you know that? And if so, what do you understand it to be?
Commissioner, I've heard about the judicial capture, but I don't think that that's a fair criticism to the judges. It's not possible to capture the state. You know, the way our courts are busy, when I receive the file and I'm supposed to pray, I normally work through the night for the files that I'm going to deal with them in the morning. So I cannot see any of our judges being captured.
You say you heard about it.
I've heard.
Yes, when you heard about it, what do they say it is? What is this thing when you hear about it?
I've heard about it from the news and from that there's this judicial capture. Judicial capture.
It is. What they say it is. They say it is judicial capture, as we heard about it, when what is happening.
I think judicial capture, it's judicial influence. It's to be influenced as a judge.
Okay, thank you very much. Thanks.
Commissioner Matolo-Lepu.
Thank you, Deputy Chief Justice. Good morning, Mr. Mahlangu.
Good morning, Commissioner Matolo-Lepu.
Okay. I know that you said you always wanted to be on the bench or a magistrate, but what I wanted to find out from, when you were an advocate, did you get enough briefs to sustain you? And if so, who were getting briefs from? Because I'm quite concerned about that.
Oh, yes, Commissioner Lepu, I was one of the privileged that was getting briefs. I've never struggled as much of the people are struggling. If I may say out of context, is that people are struggling at the bar with briefs, but I'm one of the privileged. I think it's because of my experience and because people knew that I was at court. Because as an attorney, Mr. Matolo-Lepu, I'm sure you want to brief a person that has confidence of appearing in court. So some of my briefs were coming from the state attorney and some of my briefs from the private attorneys.
Secondly, I hear that you are assisting pupils. Are you aware that the Legal Practice Council is actually assisting pupils to go through pupillage through SACITA?
Yes, I'm aware, Commissioner Patology. I'm very aware, yes.
I urge you to encourage them to apply through that. Okay.
For pupillage.
Yeah, assistant through SACITA.
Come again, Commissioner?
I'm saying I'm urging you to advise them to apply through the Legal Practice Council, you know.
Yes, Commissioner, I'll advise them to do that.
Thanks.
Thank you.
Commissioner Pillay.
Thank you, DCJ. Good morning, Ms. Mahlangu.
Good morning, Commissioner Pillay.
Ms. Mahlangu, I'm going to put an overriding concern that I have. I've been through your judgments and I find that a bit of the reasoning gets a bit muddled in your judgments. And I don't have time to take you through all your judgments, but perhaps I can just reference one. Can I ask you to open up the Msongelwa judgment? It's on page 84 of your bundle. Do you have the judgment?
Yes, I'm just about there.
Now, can I ask you, when you selected your judgments which you wanted to showcase for the commission, why is it that you chose this judgment?
Let me check.
It's on page 84.
Commissioner, unfortunately, oh, okay. If you can look at this judgment, I penned it in 2020, so it was few months after I started my acting stint. I placed this judgment here. If you can look at my judgment, I made them deliberate that the earlier judgment that I penned to the recent one, to see the improvement that I had in my judgments.
Okay, now I understand
Yes,
that. So this judgment deals with amendments and it deals with exceptions. Are you saying to us that you put it in to show how you developed over time?
Yes, to develop over time, yes.
Okay.
Yes.
And you accept that your findings in relation to, let's deal with the amendment, for example, that your handling of the amendment was not ideal at that stage?
Not necessarily Commissioner Pillay. Yes, when I was dealing with this matter, I thought the amendment was ideal.
Your handling of the amendment?
My handling, yes, my handling of amendment, yes.
All right, let's just look at that. In this case, the amendment application, the notice of intention to amend was brought in December 2019. And the amendment there was no objection to the amendment. And ordinarily what would happen then is the applicant for amendment would file amended pages. That's the simple working of Rule 28. You agree with that?
Yes, yes,
But the amended pages were not filed in time.
yes.
And so what the defendant did is it raised a point in the exception that the amendment was not properly effected because it had lapsed, and that by the time the plaintiff had filed the amended pages, it was actually just too late to do so. You recall that?
Yes,
yes.
yes.
What I noted from your reasoning was that you didn't approach the matter on the same vein as the defendant argued it. In other words, non-compliance with Rule 28.7. You approached it on the basis of the application of Rule 28.4, which is dealt with something else completely. So 28.4 deals with where you can bring an application for leave to amend once there is an objection to your amendment.
Yes, I understand you.
So I just wanted to get a sense of why it is that you approached, because amendments are really, it's like a basic procedural issue that judges have to deal with. How it is that you dealt with the amendment before you. Just looking at your judgment, there doesn't seem to be just a kind of a coherent approach to the argument before you and the basis for your decision eventually to dismiss the complaint raised by the defendant.
Commissioner Pillay, yes, I understand your question, and that the reasoning that I followed was not in terms of what the defendant has pleaded. Is that your question?
It wasn't what was raised in argument before you.
Oh, yes. Yes.
And you see, it had a further implication because the exception, when it was argued before you, you considered, when you considered the exception, you took into account both the amended pages as well as the unamended pleadings. So in other words, because you had in a sense mishandled the amendment, it bled into your handling of the exception. Because when you considered the exception, you considered it based on the amended pleadings.
Yeah. No, I understand your concern. When I dealt with this matter, I was of a view that because the amended, the notice to amend was not objected, the plaintiff was to file the amendment at any stage.
Yes.
Yes.
And not that in terms of 28(7), it was peremptory, he had to file it within a particular period of time.
I note your
Yes.
concern. Thank you.
Thank you, DCJ.
Commissioner Baloyi?
Thank you, DCJ. Good morning, Ms. Mahlangu.
Good morning, Commissioner Baloyi, SC.
Ms. Mahlangu, it's in similar vein about judgments, and I think the proposition that I want to put to you, or why I'm raising this with you, it's about whether you are ready or have gained sufficient experience in both practice and your acting stints, that you've gained sufficient experience that you are ready to be recommended. Now, if you look, and I'm looking just at two judgments, only to try and illustrate where my concern and anxiety comes from. You've given us the judgment of Mutladi Le versus Minister of Police, and you find that at page 116 of your bundle. Now, this was an application for leave to appeal. No, this is a civil claim. Someone was arrested by the police. Right? You remember that?
Yes,
That
yes,
case,
I remember, Commissioner.
Now, this person was detained for 4 days, and you awarded 60,000 rands for that, at 15,000 rands per day. You remember that?
Yes, I remember.
Now, what I've struggled with, and maybe let me, in fairness to you, try and take you to what it is that I'm looking at. But as I do that, let me just explain my difficulty. What you've done in this judgment, I thought, firstly is, it doesn't seem that you have considered the value of the freedom of the person, the liberty of the person. This particular plaintiff, as I understand from your judgment, is he went to the police station, he provided them his contact details, he somehow was arrested, and after 4 days he was released without an appearance at court. And what you did is you did this analysis of comparing past awards, but it's not clear how, you don't say how those awards in the end factor and influence your awarding the 60,000 rands. And from this judgment, it doesn't look like you had regard to the circumstances, firstly, of his arrest, the values of the Constitution about his right to be presented before court within 48 hours after 48 hours of his arrest, the right to freedom of person, dignity, and it doesn't seem, nothing in the judgment indicates that you alerted yourself to the implicated provisions of the Bill of Rights. You don't speak to that. And you'll see at page 119, paragraph 4, where you quote what it is, the grounds that he relied upon. I don't see in the judgment that you deal with those and address them at all. Now, it's quite possible that it is oversight, and that's me thinking that perhaps it's just complete oversight on your part to deal with these things. But then, if it is oversight, then it seems it has implications for your attentiveness and alertness to principles of law that get implicated in what looks like straightforward cases, but maybe they are not. So that's the Mutladi, and I'll ask you to, I'll give you the chance to comment to that if you want to. The next one is the case of Mafilika versus the state. And this was an application for leave to appeal against conviction. Now, in this one you find at page, I think it starts at page 133. Mafilika,
Yes, I'm there,
Are you
Commissioner.
there? Yes. Now, if you go to 138 of that judgment, there's listed grounds. The appellant lodged this application for leave, and the following were the grounds. And he lists the grounds, the appellant. And there's a total of 6. And in fact, it's 5 effectively. But one of them is that you did not, the magistrate did not, consider properly that this person was, the witness rather, was a minor. In fact, let me raise two with you, was a minor, but there's also that he was also implicated in the crime itself. He was an accomplice, that is said. But then you then, in your analysis of this, you deal with this, you don't address the issue of him being an accomplice, or the allegation that he's an accomplice. You deal only with the fact that he's a minor, and that's all you address, and you find this at paragraph 20, the end of paragraph 20, and at paragraph 21. That's all that you deal with. You don't deal with the other grounds that have been raised, and then, of course, you dismiss the appeal. But you've dealt only with one ground of appeal. And again, it's either it's oversight on your part, which is serious. And I note that you wrote the judgment with Judge Jaje. I note that. But you were the scribe, so I'm raising this with you. That you either completely had, overlooked the other grounds for appeal, which is quite serious, because maybe if you had paid attention to them, this appeal may well have succeeded, and I'm not discussing that for now. Or you didn't consider them to be important grounds to be addressed, and I'm not sure which. But both of these raise concerns for me about whether you are ready, one can be confident that you are ready to be appointed and the public is safe in your hands. What do you say about that?
Okay, thank you, Commissioner Baloyi. I think I've gained enough experience. I have, if I calculate, I have more than 23 years experience in the legal field, wherein I've been through all the spectrum of my legal profession. But what I can say with the first case of, is it Mafilika? Yes, the first case of the unlawful arrest that you mentioned, we are guided by the SCA relating to this matter. There's this recent SCA judgment that came out that guided me in coming to this conclusion of granting the plaintiff 15,000 rand per day. And the other thing, Commissioner, is both matters, for me not to deal with the constitutional rights of the plaintiff in this judgment. I admit that it wasn't my oversight, but I'll take note of that, because in some of my matters I do deal with the constitutional issues, constitutional right of the plaintiff, especially if they were raised. But if they were not raised in this, like in this matter, it is an oversight that I did not deal with it. And relating to this other matter, Commissioner, where in a minor, the issue was that the minor was not properly, has not properly taken an oath. In my view, that was the main issue in this matter. That is why I dealt with it alone. Then I did not deal with other issues. But I also note that for me not to deal with, it was not an oversight on this one. I just took it that for this matter to proceed, the main issue was that the minor's oath was not taken into consideration.
Thank you, Ms. Mahlangu. Thank you, CJ.
Thank you, Commissioner Baloyi.
CJ, I would like to also pursue a similar line, if I may.
Yes.
Good morning, Advocate Mahlangu.
Good morning, Commissioner Ngugaitobi SC.
Yes, can I just ask you about the judgment of Ketleng Refir?
Okay, Commissioner, before you go there, Ketleng was also appealed, and the appeal was heard on Friday, if I'm not wrong, and the JP was one of the judges that sat on that appeal. So you may ask me questions, but I will request that you don't ask me questions that will be like I'm defending my judgment.
Yes, you will tell me if it's uncomfortable, then I won't pursue it any further. But
thank you.
It somewhat unsettles me, because basically the facts in that case is that there was sewage that is spilled into Costa River.
There were 3 cases, Commissioner.
Yes, let's
If you
take
can-
case one.
Sorry?
Case one, which involved Ketling Refir. You've quoted this at page 48 of your application. But let me just pursue this one line. I mean, let's take the one case where there is sewage that's spilled into a river. An application is then brought to compel the municipal manager of Ketling Refir, firstly to stop the sewage because it's contaminated water, it's dangerous water. That application then succeeds by way of a rule nisi. The municipal manager is told in the rule nisi that they need to bring a report to court to detail what steps they have taken to stop the contamination. You remember those facts?
I remember, Commissioner Ndugaitobi, like I've said earlier, those were one of the reasons why this matter was upheld.
Yes, now I understand. I'm not going to ask you about those particular
okay.
facts. I just wanted to make sure that you remember what I'm talking about. The municipal manager doesn't comply. You remember that?
On what page is it, if maybe you can just take me to it?
Yes, I'll take you now, but again, this is just by way of background. A contempt application is brought before you for non-compliance with the terms of the rule nisi. You then dismiss the contempt. Correct?
Yes, I think so.
You say you've dismissed it because by the time the application came before you, the rule nisi had lapsed. But you totally ignore the fact that for the duration of the rule nisi, during that period that it had not lapsed, he was in contempt. Now, that's what I'm trying to understand in your reasoning, because the reason I'm worried about this is because if there is spillage of contaminated water to a community in a township, that implicates environmental rights under Section 24 of the Constitution. And when there is a contempt application to compel the municipality to do its job to clean the water, and it comes before a judge, I would expect a judge to be specially alert in cases of water contamination and in cases where the municipality fails to discharge its obligations and not easily to dismiss an application such as this on such, I would say, tenuous grounds. And that is why I'm worried whether or not you have, in fact, the requisite technical ability at this stage. Do you want to comment on that?
Commissioner, I thank you for the question. I do have the technicalities to deal with the matters that appear before me. But as I've said earlier, that is one of the issues that were raised in the appeal, and I don't feel comfortable in answering it.
Thank you.
We all understand. I just want to reassure you, Ms. Mahlangu. We all understand the principle of sub judice, but I think it would be entirely, open to you to discuss your judgment and what led you to deciding in a certain manner, because you played your part. Your functus officio is out of your hands.
Oh, okay.
What the senior court does is something else.
Thank you,
In
Please
case
just-
someone else-
Justice Maya. Thank you very much.
I'm asking for a follow-up just on this, just one quick.
Yes, Commissioner.
Look, I mean, on this question that Commissioner Ndugaitobi is asking, really it has nothing to do with that. The question is, at the time when the municipal manager did not act, the order was valid, it was there. But the question is, did you understand that? And how on earth would you dismiss it simply because at the time of hearing the matter, then the rule nisi has lapsed? Can you balance this?
Yeah, thank you for the question, Commissioner Nochese. The reason why I dismissed it by then, in my view, was that there was no longer a rule nisi in front of me. It has lapsed. the one in which it was said the particular municipal manager had contempted on. That's the reason why I dismissed this application. Thank you. And I'm waiting for the judgment on the appeal one so that I can learn more and have more opening on what has happened in the appeal. Thank you, Commissioner.
Thank you, Ms. Mahlangu. Do we have questions from the Commissioner Steinberg?
Good morning.
Good morning, Commissioner Steinberg.
One of the cases you cite as being one that you regard as the most significant, on page 7 of your application, it's Nkomo Marco versus the DPP.
I'm there, thank you, Commissioner.
You say it was significant because there were unique facts and unprecedented question of law, but you don't say what the unprecedented question of law was. Could you tell us what it was?
The application that was brought by the, in this, they were no more accused, they were applicants. They wanted the proceeding, the prosecutorial proceedings against them, against him, specifically to be stayed.
Yeah.
Yes, so for me, it was, as an ex-prosecutor, we used to have such applications. For me to deal with them on the other side of the law, it was very interesting for me. And especially because Mr. Nkomo took this matter as far as to the Constitutional Court. Unfortunately, the Constitutional Court, it was only decided on paper.
But what was unprecedented? Are you saying unprecedented for you or unprecedented in our law?
For me.
Oh, I see.
Yes.
Are you aware that there's a leading SCA judgment?
By then, it's a 2019 case, I think.
Yeah, there's a 2012 leading judgment on the question of what constitutes unreasonable delay on the part.
Oh, I was not aware about that, Commissioner.
Okay.
Thank you.
Thank you, Judge.
Commissioners on the virtual platform, do you have questions for this candidate?
I do.
Go ahead, Commissioner Bernard.
Thank you. Ms. Mahlangu, we have that one complaint, or the complaint raised, or not complaint, the comment that, there might be issues with judicial temperament. And in your discussion with Commissioner Nyambe of the good attribute, you raised the fact that you quote in your words, a very strict person. What did you mean by that?
Good morning, Commissioner Bernard.
Good morning.
By saying I'm strict, I always regard myself as a perfectionist. I prepare and I want my court to be run in a specific way, and so that we can be able to finalize our matters. By being very strict, it does not mean that I do not allow the litigants to present their cases as they want, but by being strict, I mean also my time management as a judge. Otherwise, in the Northwest Division, where you have more than 100 unopposed, and you have the opposed, the urgent application, if I'm not strict and be able to manage my time correctly in court, I will not be able to finalize my matters before 7 in the evening.
So, with those pressures, and also maybe pressures that could be raised by being perfectionist in that way, is that not some, when the members express the views that the candidate is short-tempered, is that not perhaps what they could have maybe read into the type of strictness in dealing with the court?
I don't think so, Commissioner. I think a short-tempered person that I know is the person that will harass or shout or do all the... I'm not that kind of a person. Like I say, no matter how strict, no matter how I'm a perfectionist, no matter how much I can manage my time, but each and every legal practitioner that appears before me has enough time to present their cases.
Thank you.
Thank
if you could work on any aspect of your own judicial skills and training, which aspect would you like to focus on improving?
I've attended the most important one that I wanted, which is the judgment writing. I think that is the most aspect that I wanted, because Commissioner Barnett, as a prosecutor at NPA, they invest a lot in training, so I've attended enough trainings on different fields. So I think the aspect that I would like as a judge is to attend the intense judgment writing, but I did attend one that was arranged by Judge Madiba.
Thank you. DCJ, if I might just have one more question. It's just a question about the companies that the candidate was involved in. I know I've already asked 2 questions.
No, you may ask.
Thank you. Mr. Mahlangu, one of the companies, I seem to see the name was a taxi company or something like that. Would you be able to adjudicate disputes where taxi companies are involved impartially?
No, Commissioner Barnett, thanks for the question. The reason why we wanted to start that company, we realized of the high cost of petrol in South Africa. So the reason why we said taxi, we wanted to encourage taxis and taxis generally, not owners. We wanted to introduce the gas stations specifically for taxis at the taxi ranks. That's the reason why I wanted to start that company. Not that I'm interested in taxis, I don't even know how they operate, but we wanted to form the company wherein we can be able to establish gas stations next to the taxi ranks or on the routes that are normally used by taxis. But unfortunately, as I've said, that company did not take off because we started it in 2019 and then COVID came.
Yes, I know, but I think the question is as to impartiality. Just obviously, you struck up a relationship with people in that industry, and the question is if that does not in some or other way impact on impartiality. We did.
Thank you, Commissioner. We did not engage with the taxi owners or drivers or anyone else. Like I said, we call it taxi what company because we wanted to establish the gas stations next to the taxi. Not that we were going to engage with the taxi owners. We were going to engage with the Department of Energy that will give us a license to establish those gas stations. And encourage taxi owners and drivers to install the gas pumps or whatever into the taxis. But we were not going to be involved in that.
Thank you, DCJ.
Thank you.
Follow up, DCJ?
Yes.
Thank you very much. I just want to follow up on the issue. I mean, initially when the issue of complaints about temper and all those things came, I was convinced that this is one of those allegations that people will raise, particularly the litigants themselves. But after saying that you are strict, it made me think that perhaps maybe there are certain things that you need to look into. Because I'm just thinking that when, especially in criminal trials, and we know how cross-examinations can go, right? Where people just ask irrelevant questions and all those things. And it might be that perhaps maybe you get in and stuff. So the point that I'm trying to make is, have you considered perhaps that when the right to fair trial, the right to liberty are implicated, and the manner in which perhaps you may have conducted some of the trials may have induced a perception that perhaps you are not patient, perhaps maybe you are rushing a litigant or their representatives on the verge of being strict? I'm not sure. Is there something that perhaps maybe it's something that you should look into rather than just dismiss it?
Are we not speculating, though, Commissioner?
No, I accept that, DCJ. I do accept that. In any event,
I didn't know that strict was a swear word. I would like for judges to be strict.
I accept that, DCJ. I do. But just just a thought that came to my mind.
Well, let's have an answer for what it may be worth.
Thank you, Commissioner Marumahai. As I've said earlier, that unfortunately this comment it's not clarified, it's not clear, and it's not, if maybe they could have told me where did I show any signs of short-temperedness. And then in criminal cases, Commissioner Marumachai, I become, you let it go. You let the legal representative do their work, the cross-examination and everything. You cannot interfere in the criminal trials or civil trials. That's why I say, if it was clarified, this comment, I was going to be in the best position to say what happened on that specific day.
I accept that. Thank you very much, DCJ.
Thank you.
Thank you, Commissioner. Anyone else on the virtual platform? No. Well, it does appear that we've come to the end of your interview, Ms. Mahlangu. Thank you very much for making yourself available for the vacancy. You're excused.
Thank you very much to you, Justice Maya, and to the commissioners for the opportunity of sitting on this chair. Thank you.
Thank you, ma'am. You're excused.